Count 1, involuntary manslaughter as to Madison Baldwin. Guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Meir. Guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. Guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. Guilty of involuntary manslaughter as to Justin Schilling.
Thank you, foreperson.
And there it is, the guilty verdicts that came down at about 7:30 last night. James Crumbley guilty, all 4 counts of involuntary manslaughter. Good afternoon to you. I'm Christy McDonald. Thanks so much for joining us here on the Daily Plus Live as we kind of wrap up our coverage of the Crumbleys on trial here, the first parents ever to be prosecuted criminally and held responsible for the actions of their son, who was a mass shooter at Oxford High School back on November 30th of 2021. As we sit here today, knowing now that the verdict is in, there's all of the reaction and everything from the press conference last night from the Oakland County prosecutor and, more importantly, from the families of the victims, as they have had to watch now 2 trials and had to go through the sentencing of the teen shooter himself. And again, saying what's next in this case, who else could be held responsible. So I wanted to start off today hearing from those parents, because it's them who have to sit through this trial, who have to live with the fact every day that their children are not there with them, and who are the ones asking the loudest questions of how could this have happened. So Mara McDonald spoke with the parents last night after the press conference in what they feel should be done now and what everyone around the country should be taking from the verdict that was delivered last night.
To this day, and after both of these verdicts, do you guys think that you still really know what happened that day, and is everybody fessed up to what happened that day?
Absolutely not. No, not. In fact, I just found out the other day that there was a person that lied in their deposition. That's what we're fighting here, right? The school is protected, you know, so we're ready to take it on. We're ready to take it on.
Do you, Steve, I'm curious, Buck and I have talked about this at length, getting through these 2 verdicts and the shooter's plea, I mean, is it like you're marking stuff off and there's still this one big thing just sitting out there that just weighs on you?
Yes. I mean, that's the short answer. Unfortunately, I don't think it's even being able to stop at just the school, because as we talked about, it's a matter of getting the message out and stopping this from happening again. And that doesn't just, you know, that is not going to happen just by if we stop at the school district, right? So there's a journey beyond that, changing legislation, getting the message out, making change.
Yep.
Do you guys feel that your time is well spent going to that school board now and saying anything after these verdicts? I heard you. I sat there and cried in the back of the room as I listened to you that day at that school board.
My message to the school board was that I was here, that I'm letting them know how I feel and what they're not allowed to do. And the one thing, whether they stay or they leave like they should, they know our kids' names. They don't have that luxury to forget them. They're not given that right. Just like the parents today, they don't get a free pass, and neither does the school.
Craig, you too?
Absolutely. There's a lot involved in any school district, and to neglect your responsibilities and not implement the proper policies and not stand up for our kids and be that voice and show them your leadership, and it's absolutely has to happen. Accountability is not just a word that we've been throwing around loosely. I mean, it's what we want. It's absolutely necessary.
Thanks, you guys.
You have to feel for those parents, and not only those parents, but so many parents and children in the Oxford Schools community who this does not mean closure for them. This is just another part in the journey of moving forward now with the experience and the trauma that they hold within them. But as we look at the next steps, you have one family here, the Crumbley family, that has been held criminally responsible. So as we look at what the next steps are for the Crumbleys, I want to bring now Jeffrey Schwartz in with us. He's an attorney, he's a former prosecutor, a former judge, and now a professor at Cooley Law School. Jeff, it's great to see you again. Thanks so much for joining me today.
Nice to see you too.
All right, let's go ahead and talk about sentencing for the Crumbleys. We know that they have the max of 15 years for involuntary manslaughter. Both of them sentenced on the same day, April 9th. What does that do for families that only have to show up once to give those victim impact statements?
Well, this will be the second time for all of them, so it isn't a matter that they've only done it once. It does save them the pain of having to do it a third time. I agree with that. I think that what we're going to see is probably some disappointment in their minds, even though they already know it, that the most that either of the Crumbleys are going to get is 15 years concurrent on all 4 counts. They've already got 2.5 years in. I don't know how long they have to go before they're entitled to some sort of release, but I don't think it's going to be everything they want. They obviously are out, for lack of a better way to put it, for more pounds of flesh against the school board. And that to me has always been appropriate. I've not always agreed with the prosecution of the parents, but I did have some problems with the fact that the people who work for the school were actually still working for schools and not being held responsible for anything.
Yeah, I do want to talk about schools and what could be the next step here. Before we leave the Crumbleys, let me ask you this. Obviously, if you're a defense attorney for them, do you appeal this conviction? And what would be the things that you would be able to base an appeal on?
My personal feeling is that there was a lot of overreaching by the prosecution. I think that they asked for a lot of things of Judge Schaefer that they got. There's a rule of evidence that says if the probative value is outweighed by the prejudicial value, that you don't introduce it even if it's relevant. They were allowed to keep the jury angry, and that was their main strategy. Get them angry at the start, present the evidence, which is kind of perfunctory, and then make them angry again. And the closing argument of Ms. McDonald was in fact a "you should stay angry" argument. So that's where they came from, and a lot of the evidence that was introduced really wasn't probative, and I think that it was just prejudicial, including Ethan's journal. The idea that they introduced that journal, which neither of the parents had any knowledge of, at least there's no evidence to show that, kind of shows that that was his frame of mind, but he wasn't actually testifying, and he actually could not be cross-examined on what he said in there. So I have some real problems with some of the evidence that was introduced, and that will be the basis of the appeal.
Absolutely. All right, let's talk about what the next step, what the parents want to see, and they say they want to be holding the district accountable. We did get a ruling from Oakland County Circuit Court saying that there is governmental immunity for the school district, but there is a federal civil case that is trying to go forward. So when they say holding accountable, what could possibly legally that look like, Jeff?
Well, first of all, I'm really amazed that the 2 particular people that met with Ethan and the parents were never brought to bear for their negligence. If in fact the parents were negligent, then why weren't these 2 people who had an absolute duty under statute not held responsible for what they did not do? And now they're saying, well, he really wasn't a danger. Well, if he really wasn't a danger, why did they let him stay in the school and not force him to leave with his parents? And they put him back in a classroom, which is even worse. So I'm still waiting for some accountability from them where they're talking out of both sides of their mouth. And I think the prosecutors should have considered charging them as well as the Crumbleys. If they were going to charge the Crumbleys, they should have charged these 2 particular people.
Give us a sense in terms of some legalese. The fact that Sean Hopkins, who was the counselor, and Nick Ejak, who was the dean in this case, they've testified now in Jennifer's case and in James' case. Can that testimony be used against them in any kind of forward-seeking suits?
If they don't have any kind of immunity agreement, that is what we call use immunity, where what they testify to can't be used against them if they're charged, then they are just as susceptible of being charged if, in fact, Ms. McDonald chooses to do that. I think there's a lot of pressure from these parents, not only to hold these people responsible civilly, they would like to see them charged. And I'm on that score, I'm very much in favor of that. I think that if you're going to charge the parents, you're going to have to charge the people that had the legal duty to protect all the students in that school.
Jeff, we talk so much about the reverberation of this case, not only here in Michigan, but across the country. Give us a sense of what you think conversations are happening right now in other prosecutors' offices around the country, and also maybe in school districts at the highest administration level of, we just saw this play out and heard staffers take the stand and talk about threat assessment, which seemed to be non-existent. What do you think could be happening around the country?
Well, first of all, parents have to be very concerned, especially in areas where there are gun rights advocates, have got to be concerned that there's a possibility of a double standard applying in some areas of Michigan and not in others. This is not really precedential. There's nothing binding on any prosecutors to bring these kind of charges. And it's really going to depend upon community interest and community pressures. When it comes down to the schools are now going to be and have to be more aware of troubled kids and finding ways to isolate them when necessary from the general population of the school. And they're going to have to be more conscious of the idea that some of these students could be armed. And I think they're going to have to screen bags a little bit more when they come through, and there's going to have to be more protection for the kids. As it relates to parents, well, I talked about the parents. I think prosecutors are going to have to sit and talk about how far do they want to go. Does this only apply to guns? Does it apply to knives? Does it apply to a baseball bat that the kid gets a hold of and beats some other kid up with? How far does it go? Does it only incur when there's death, or can it be serious bodily injury? There's a lot here that is left open that I think is going to be a problem for the authorities in Michigan and in other states.
All right, Jeffrey Schwartz, an attorney, former prosecutor, judge, and a professor at Cooley Law. Thanks so much for the expertise today. We really appreciate it. You have a good weekend, okay?
You too. Have a great day.
All right. As we continue now, as our coverage, as we kind of are wrapping things to a close here with the guilty verdict for James Crumbley. Coming up next, we're going to talk about, I think, the key moments in the trial, what might have turned things for the jury. We haven't heard from a jury foreperson or any member of the jury yet, but we're going to point out some of the key moments from the last 6 days. So stay with me. We'll be right back.